Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Vote or affirmation, announcements by the President, bills brought from the House of Representatives, petitions, papers.
Acting Leader of Government Business.
Madam President, I have the honor to lay on the table the following paper is listed on the order paper in the name of the Minister of Education. The ministerial response of the Ministry of Education to the 13th report of the Joint Select Committee on State Enterprises on an inquiry into the operations of MIC Institute of Technology with specific reference to the high dropout and failure rate of its trainees.
Minister, could you just also, in the absence of the Minister of Works and Transport?
Yes, please, Madam President. I have the honor to lay on the table the following order paper as listed in the name of the Minister of Works and Transport. The ministerial response of the Ministry of Works and Transport to the 8th report of the Joint Select Committee on Land and Physical Infrastructure on an inquiry into the effectiveness of measures in place to reduce traffic congestion on the nation's roads. I thank you.
From committees.
Senator Mark.
Yes, thank you, Madam President. Madam President, I have the honor to present the following report as listed on the order paper in my name. The 25th report of the Public Accounts Enterprises Committee, 5th session, 2019-2020, 11th Parliament, on an examination of the audited financial statements of the Trinidad and Tobago International Financial Center Management Company Limited for the years 2010 to 2017.
Senator C. Prasad.
Madam President, I have the honor to present the following reports as listed on the order paper in the name of Senator Tahika Abika. The 26th report of the Public Accounts Committee, 4th session, 2018-2019, 11th Parliament, on an examination of the audited financial statements of the Environmental Management Authority for the financial years 2010 to 2012 and the authority's expenditure and internal controls for the years 2010 to 2018. The 28th report of the Public Accounts Committee, 4th session, 2018 to 2019, 11th Parliament, on an examination of the report of the Auditor General on the public accounts of the Republic of Trinidad and Tobago for the financial year 2018.
Urgent questions.
Senator Mark.
Thank you, Madam President. To the Minister of Agriculture, Land and Fisheries, as regards the reports of smuggling of birds and other wildlife between Trinidad and Tobago and Venezuela, can the Minister indicate what action is being taken by his ministry to address this issue?
Minister of Agriculture, Land and Fisheries.
Thank you very much, Madam President. Madam President, the incident yesterday demonstrates the importance of the work of the Ministry of National Security in protecting the borders and ensuring that there are patrols, in particular, that area that we've spoken so much about, the area between Trinidad and Tobago and Venezuela, insofar as it relates to the illegal trade in wildlife and illegal trade in other commodities and the illegal movement of persons between Trinidad and Tobago and Venezuela. Madam President, the interception is one of several interceptions that have taken on the sea. And when these interceptions are made, it is not only wildlife. In this case, it was only wildlife, but sometimes it is wildlife and other things. This has been possible because of the increased attention the Ministry of National Security has placed on this particular issue, Madam President, but it also follows the decision supported by the Parliament to increase the fines relating to illegal activity in wildlife, and that was done. It was effected in January 2019 through an amendment to the Conservation of Wildlife Act. Madam President, you would recall that recently in the miscellaneous bill, which was passed in both houses and assented to, there was included an amendment to the Summary Offences Act, which deals with the sections which deal with cruelty to animals, section 78 to 81, and the fines in respect of cruelty were increased to $100,000 and the term of prison to 1 year, and that was an increase from $200 and 2 months in prison. Madam President, we also in this House passed recently the Animal Welfare Bill, which is the short title I have given it. It's also called officially the Animal Diseases and Importation Bill, and that is laid in the other place for debate now.
Minister, your time is up.
Thank you very much, Madam President.
Senator Mark.
Madam President, in light of the fact that several of these individuals who were intercepted by the Coast Guard and probably are now in police hands or in the hands of the police, and in light of COVID-19, I would like to ask through you, Honorable President, to the Minister, whether these individuals who were caught by the Coast Guard have been subject or have been subjected to any kind of tests as it relates to COVID-19, having regard to the fact, Madam President, they were caught on the high seas coming from Venezuela.
Senator Mark, that question does not arise. Next question, you have one more.
Can I ask the Honourable Minister what measures or what further measures would be taken by the Ministry of National Security to address this smuggling, not only of wildlife, as he has indicated, but also commodities? What other specific steps are being taken to tighten our borders so that we can, in fact, address this incursion through smuggling by various persons out of Venezuela into Trinidad and Tobago?
Minister.
Madam President, I'm pleased to say in the coming weeks, not years nor months, weeks, the government will take delivery of one of the much maligned Cape-class vessels coming out of Australia, despite several attempts to put us in all sorts of embarrassment, us meaning the people of Trinidad and Tobago. The vessel appropriately in honor of APT James, that legendary parliamentarian, would arrive here as planned, within budget, within specifications, and unlike the fishing vessel which was brought to patrol the waters, this vessel will increase and improve our ability to respond to what is happening from Puerto Rico down to Trinidad. And that includes between Venezuela and Trinidad, and that includes wildlife and whatever else is coming from there. I thank you very much. Yeah.
No. Just 1 second. It is the beginning of the sit-in. Senator Hussain and Senator Mark, please conform to the standing orders.
Questions on notice, questions for all answer.
Acting Leader of Government Business. Acting Leader of Government Business.
Madam President, in my excitement to announce the arrival of our vessels, I must admit I confused Mr. James with the Border Patrol vessels. There are so many vessels that have been brought. In my excitement, you never got around to putting yours to use, but in my excitement to honor Mr. James, I admit that I got the name confused. Madam President, there are 7 questions on notice for response. The government intends to respond to 6 of those questions. Those are 118, 119, 130, 149, 151, and 152. I thank you.
149.
149, Madam President.
So, 1, 2, 3, 4, 5. So you're asking for anything? No, questions 96 and 97 are not being answered, correct?
No, please, Madam President.
Question 152 is being answered today.
So we are answering 118,
Yeah.
119, 130, 149, 151, and 152.
Great. Senator Mark.
Question number 118 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Madam President. Madam President, in response to the matter raised, I am not aware that the protest action taken by the Public Transport Service Corporation workers in February 2020 was as a result of health and safety issues and the limited availability of buses. In fact, I have been informed by PTSC that there are no health and safety issues of concerns that would prevent the drivers/conductors from driving the buses at this point in time. Additionally, the buses currently deployed to service the routes have been inspected by the licensing division and deemed roadworthy for the drivers to operate. In light of this, Madam President, the concerns regarding any measures the government may intend to take is therefore not applicable. However, it is noteworthy that the protest action is more likely as a result of outstanding collective agreements for the period January 1st, 2015 to December 1st, 2017, and January 1st, 2018 to December 2020 between PTSC and the Transport and Industrial Workers Union, which is the recognized majority union for the daily and hourly and fortnightly paid employees. As part of the process, I am to advise in response to the question of the Chief Personnel Officer, the PTSC has already submitted additional information for the period January 1st, 2015 to December 31st, 2017 to the Ministry of Works and Transport, and this has been forwarded to the CPOs, and we await the next step. Thank you.
Senator Mark.
Madam President, can the Minister indicate whether the parties have met directly on this matter? That is, the CPO representing the state and the Transport and Industrial Workers Union to deal with those outstanding collective agreements.
Madam President, we would have submitted the necessary requests to the CPO, and we await further directions from the CPO. We have no control over the meetings between the CPO and the different bargaining unions. So I cannot answer if they have met at this point in time. If the minister files a another question through the process, I will seek the information. Thank you.
Senator Mark.
Can the Minister indicate what were the items that the Ministry of Works and Transport would have submitted to the CPO with a view to having the two parties arrive at a speedy settlement, given the outstanding collective agreements in question.
Minister.
Madam President, the question as asked had to do with health and safety issues, and that is the information that I was provided with. Again, if the Honourable Minister wants questions on negotiations, he will have to file further questions through the required system, and I'll be happy to answer those questions. Thank you.
Question number 119 to the Prime Minister.
Acting Leader of Government Business.
Thank you very much, Madam President. Madam President, it is well known by all concerned that it is neither practical nor possible to satisfy the demands of every housing applicant in the country, including applicants in Tobago. Accordingly, Cabinet has agreed to collaboration between the Ministry of Housing and Urban Development and the THA under the Settlements Division of the THA to support ongoing programs geared towards increasing the numbers of safe and affordable housing solutions, primarily to lower and middle income groups in Tobago. This has been achieved through the continuous disbursement of grants for maintaining and improving the quality of the existing housing stock, by expanding the number of subsidized housing units being constructed, and by expanding the development of service lots and the construction of affordable housing. Madam President, I wish to highlight the following programs. The Home Improvement Program that is very successful across the Trinidad and has been extended to Tobago through the Tobago House of Assembly and the Division of Settlements in particular. And so far, through that program, a home improvement grant has been rolled out, home completion program, and a home improvement subsidy. The value of these programs has been 20 million over the last 4 years, and over 2,500 families in Tobago have benefited. The second program is a beneficiary-owned land program. It's a subsidy for starter homes. It targets new home construction, and it seeks to supply suitably qualified applicants with financial support to construct a starter home. Over the last 5 years, $11.9 million has been disbursed, and that has benefited 550 families. The HVIP, another successful program in Trinidad, has been rolled out through a collaboration between the Ministry of Housing and the THA, and that is expected to benefit a significant number of families through the aided self-help approach, which will target those residents living in what we describe as derelict homes. Fourth, the new home construction. The Tobago Executive, the THA Executive Council agreed in 2019 to develop 2 new areas, the Riseland and Adelphi housing developments. Riseland involves 54 housing units, and Adelphi involves 240 housing units. And finally, the Shervan Development Project, Madam President, is between the THA and a developer that the THA is looking to recruit to design, finance, and construct an integrated development with approximately 250 housing units in the first instance. I thank you.
Senator Mark.
Madam President, can the Minister indicate, in the case of the Shervan Development Project between the THA and some developer, can the Honourable Minister elaborate as to the current status of this project?
Senator Mark, I won't allow that question. Any other questions?
Arising out of answers given, you ask questions.
Yes, but answers.
Well, I'm guided.
Okay,
Madam.
good,
I'm guided.
because I would have given you an explanation.
Yeah, thank you, Madam.
Yes.
Madam President, can the Honourable Minister indicate how many people have benefited from the 2 new projects? No, may I recast that? He mentioned something called is it the HI, some new program with self-help? HVIP, Madam President. Can you share with the Senate how many persons in Tobago, residents in Tobago, would have benefited from this particular project or program that you have outlined?
Minister.
Madam President, since I myself made a mistake earlier, I understand my colleague may be confused. So I'll go through it very quickly. The Home Improvement Program, which involves the grant completion program or the subsidy, has benefited 2,500 families and has cost 20.1 million. The beneficiary-owned land program, that's a subsidy for starter homes, it's cost 11.9 million and it has benefited 549 families. When completed, the new home construction program, which involves Riseland and Adelphi, will benefit 300 families in the first instance, that is 54 at Riseland and 240 approximately at Adelphi. The Shervan, which is currently being designed for the purpose of seeking a developer, will benefit 250 families in the first instance. And finally, the Housing and Village Improvement Program, which was very successful so far in Trinidad, is being introduced in Tobago and would benefit those residents who are in need of aided self-help for their existing homes. Thank you.
Mark.
Can the minister indicate any time frame for the operationalization of this program? He mentioned the village and community program. Is there a time frame? Is it being introduced? So I'm asking him whether he can share with us a specific time frame for its implementation.
I think we get it, Senator Mark. Minister?
That it's in the process of being introduced, and I'm sure that the COVID regulations has restricted what could be done, but it's in the process of being introduced. And now that the government or the state has moved to be fully operational, I'm sure that it would be accelerated for the people of Tobago to benefit from this program, which has worked very well across Trinidad. And we're all happy that it is now being introduced in Tobago. Thank you.
Next question, Senator Mark.
Question number 130 to the Minister of Health.
Acting Leader of Government Business.
Madam President, I know my colleague, the Honourable Minister, has responded to this question in various ways. So for absolute clarity, I'll do it again. Madam President, under Section 5.2 of the Regional Health Authorities Act, Chapter 2905, the Tobago Regional Health Authority is subject to the provisions of the Tobago House of Assembly Act, Chapter 2503, and consequently falls under the jurisdiction of the Secretary of Health, Wellness and Family Development in Tobago. So, in relation to the first part, I would remind my colleague that this RHA is under the jurisdiction of the THA and the Secretary of Health, Wellness and Family Development in Tobago. Secondly, as the Honourable Minister has said himself, he's been advised by the Tobago House of Assembly, as has been reported in the public domain since March 2020, that the Tobago Regional Health Authority has said that it's lost confidence in the ability of the CEO to effectively perform his duties, and that was the reason for his dismissal. I thank you, Madam President.
Next question, Senator Obika.
Thank you, Madam President. Question 149 to the Minister of Education.
Acting Leader of Government Business.
Madam President, the colleague, the Minister of Education, has dealt with this matter on many occasions. So I know, as happened earlier with me, I got confused. So to remove any confusion, I will say it again. The Early Childhood Care and Education Center at Southern Gardens, Point Fortin, was completed in the last quarter of 2013. At that time, Madam President, a decision was taken by the then Minister of Education to decant the Chatham Government Primary School into the newly constructed Southern Gardens Early Childhood Center. This was done to facilitate the reconstruction of the Chatham Government Primary School on that school's existing site. Madam President, because of the onset of the COVID-19 pandemic, the construction of that primary school, the Chatham Government Primary School, was unscheduled before. It was scheduled to be completed in July 2020. The Ministry of Education is currently doing an assessment to determine the extent to which there has been slippage in some of the expected completion dates in relation to schools across the country. And once that exercise is done, the ministry would be able to say two things. When the Chatham Government Primary School would be completed, and when the Early Childhood Center, which is completed but occupied by the pupils of Chatham Government Primary School, when that would be available to function as an early childhood center. So I emphasize, Madam President, because we all make mistakes in our understanding and recollection, as I did earlier, I emphasize that the Early Childhood Center is completed and occupied when school is taking place by the students of Chatham Government Primary School since the last quarter of 2013. And this government has proceeded with the completion of that school. There's been an interruption. There will be a resumption. And once Chatham Government Primary School is completed, it will be occupied by those students who are currently at the completed Early Childhood Center in Southern Gardens, Point Fortin. And those children earmarked for that Early Childhood Center will then have a school which was completed since 2013 to attend. Thank you very much.
Senator Obika, supplementary.
For suffering people of Chatham for 5 years with a 95...
Senator Obika, no preamble. Ask your question.
After the minister's embarrassing statement.
Senator Obika, no preamble. Ask your question.
The question still stands. When will the pupils of Southern Gardens in Point Fortin be given access to the Early Childhood Education Center? That has not been answered.
Senator Obika, I will not allow that question based on the question that has been posed. Next question. Next supplemental question.
You have failed. Question number 150.
Senator Obika. Senator Obika. Withdraw what you just said, and you will apologize, because I do not want, I have said repeatedly, ask your question. Ask the question without comment, please.
May I inquire as to the reprimand for the Minister of Trade and Industry?
All right. Senator Obika, take your seat. Take your seat. Take your seat, Senator Obika. Senator Obika, in light of your refusal to comply with my instructions, I will ask you to leave the chamber now for the rest of this sitting.
Request for leave to move the adjournment of the Senate on definite matters of urgent public importance, statements by ministers or parliamentary secretaries, personal explanations.
Minister of Finance.
Thank you very much, Madam President. Yesterday in the Senate, Senator Wade Mark made several false allegations under the cover of parliamentary privilege regarding the alleged non-payment of millions of dollars in stamp duty due on the purchase of a piece of land in Port of Spain for a building project which he linked to me. Senator Mark also insinuated that as Minister of Finance, I was somehow involved in money laundering and land fraud. These false accusations have received wide publication in the media. So kindly allow me, therefore, to express my dismay that the Senate has been abused in this way to unjustifiably defame my character and to spread untruths. For the record, all of Senator Mark's allegations are false. Contrary to Senator Mark's outrageous insinuations, I did not, in my capacity as Minister of Finance or otherwise, purchase any such land in Port of Spain at an undervaluation, nor did I deprive the Treasury of stamp duty, nor did I engage in land fraud. The truth is that in December 2012, when I was in the opposition and the UNC was in government, I acquired the shares in a company that owned a parcel of land in Port of Spain. The applicable law relating to the stamp duty to be charged on the transfer of shares in a private company makes it clear that in such a case, the stamp duty is the greater of $5 per $1,000 of the consideration given, that is, the payment for the shares, or $5 per $1,000 of the value of the shares transferred as determined by the company's auditor. That is the law. The company was not transacting any business at the time in 2012, and the company's auditor, a chartered accountant, valued the 30,000 issued shares in the company at $1 per share at par value, which would yield stamp duty of $150 if the value of the shares was the determining factor. However, the company owned land in Port of Spain, which was its only asset, and the company was being offered for sale, therefore, at a price of $7.5 million. Being ever mindful of the behavior of certain individuals in the political arena and other mischievous individuals who are prone to making scandalous and baseless accusations about me, I commissioned a valuation of the market value of the land on Picton Street, and in November 2012, the land was valued by a reputable, chartered valuation surveyor at $7.5 million. 1 month later, in December 2012, I purchased the 30,000 issued shares in the company for the asking price of $7.5 million. I did not, as Senator Mark has falsely alleged, buy the land or company in question for $1.75 million. Since the payment for the shares was greater than the nominal value of the shares, the stamp duty for the share transfer was subsequently assessed by the Board of Inland Revenue at the statutory rate of $5 per $1,000 of the consideration given, the price paid, and paid by my attorneys to the Board of Inland Revenue 1 month later in January 2013, when the share transfer transaction was registered with the Board of Inland Revenue. I have in my hand, Madam President, I have in my hand the 2013 receipt from the Board of Inland Revenue for the stamp duty that was paid in accordance with the law on the purchase price for the shares of $7.5 million. And it is noteworthy that all of these transactions took place when the UNC was in government. It is also noteworthy that neither the property nor the company has ever been valued at $12 million by anyone. That is a bogus and inflated figure pulled out of a hat by Senator Mark. And it is regrettable that the media saw it fit to repeat and republish the untruths uttered by Senator Mark. As should also be obvious, I also had nothing to do whatsoever with any transaction relating to the sale, purchase, or conveyance of title of the land in question from or to any other person or company before I acquired the shares in the company that own the land. In summary, there is no truth whatsoever to Senator Mark's false allegations of tax evasion, land fraud, and money laundering with respect to the acquisition of this company by me or its associated land. In addition, there is no hidden trust deed or secret trust of any kind concerning the ownership of the land or the shares in the company. Indeed, the ownership of the shares in the company is open to public scrutiny in the company's registry and has been so since 2010, when the company was formed by its previous owners. Further, as a person in public life, I have declared my ownership of the company to the Integrity Commission and its value since 2013. Senator Mark has made false and defamatory accusations about me without a shred of evidence and without any factual basis whatsoever. As has occurred before, in my case, he cannot produce a single document to back up his false allegations, whereas I have the documentary evidence that confirms that what he has said is simply untrue. I thank you, Madam President.
Introduction of bills. The Domestic Violence Amendment Bill 2020 in the name of the Attorney General. Motions relating to the business or sittings of the Senate and moved by Minister.
Leader of Government Business, Acting Leader of Government Business.
Madam President, I beg to move the following motion. Be it resolved that this Senate agree to the following appointment to the Joint Select Committee appointed to consider and report on the Representation of the People Amendment Bill 2020. Nigel De Freitas in lieu of Mr. Robert Lehunt.
Honourable Senators, the question is, be it resolved that the Senate agree to the following appointment to the Joint Select Committee appointed to consider and report on the Representation of the People Amendment Bill 2020. Mr. Nigel De Freitas in lieu of Mr. Robert Lehunt. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
Public business, government business, motions.
Attorney General.
Madam President, before I begin, may I ask if the speaking time for these motions is also 30 minutes? It is?
Yes.
And unlike the procedure in the House, may I also ask before I begin, is it usually in the House we take them clause by clause? Is this that we take them in one group as suggested here?
To be taken, it is proposed that it be taken as one.
Much obliged, ma'am. May I then ask you to start the clock now?
The clock has started.
Much
yes.
obliged. Madam President, I beg to move the following motion standing in my name. Be it resolved that the House amendments to the Interception of Communications Amendment Bill 2020 listed in Appendix 2 be now considered.
Members, the question is that the House amendments to the Interception of Communications Amendment Bill 2020 listed in Appendix 2 be now considered. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
Amendments to clause 2, 5, 6B, 5, 7, and the preamble as listed in Appendix 2 on the order paper.
Attorney General.
Madam President, I beg to move that the Senate agree with the House in the amendments to clauses 2, 5, 6B, Roman 5, 7, and the preamble of the Interception of Communications Amendment Bill 2020. Madam President, we have, as a Parliament, engaged in significant work throughout our tenure in this 11th Republican Parliament. One of the critical aspects of reform has been in ensuring that the criminal justice system in all of its parts works in tandem with all other pieces. You have heard me on numerous occasions say that we must focus upon the operationalization of law, and I use the formula plant and machinery, people, processes, and law. Today we come on the fourth limb, which is purely law. And permit me to say that the amendment before us right now has been caused by virtue of a written opinion procured by the Office of the Attorney General, coming from no less a person than the Honorable Fayed Hussein of Senior Counsel. Mr. Fayed Hussein is, in my opinion, one of the best constitutional lawyers in the Republic of Trinidad and Tobago, who has been to Privy Council and back. Apart from the opinion of Mr. Fayed Hussein, I have also received other opinions. Now, of course, Madam President, the holding of opinions is one that has to be carefully managed. In the comprehensive opinion requested of Mr. Hussein, as Attorney General, I asked him to take a second look at my own perspective on the law, and specifically to focus upon whether this law can be passed without a special majority. In summary, Mr. Hussein, in producing his opinion, has confirmed that subject to certain amendments of the bill, that we are fully permitted to amend the bill by removing the requirement for a 3/5 majority in Clause 2, and therefore the preamble, but so as to avoid any challenge to constitutionality, and specifically to avoid any allegation that may come about in the breadth of the law being too wide, in what Senior Counsel Hussein has cautioned against a standardless sweep of the law. Mr. Hussein has recommended, and the government has accepted, that we cause a further amendment to the bill, which was achieved in the House, in sections 6B Roman, in Clause 6B Roman 5 and Clause 7 of the bill. Permit me, therefore, to address these issues now for the purposes of the record. I'd like to say that the genesis of this law comes from a concern expressed by no less a person than the DPP himself, Mr. Roger Gaspard of Senior Counsel, and also Mr. Edward Jenkins of Queen's Counsel, who has advised the DPP that the Interception of Communications Act, that is the Act in 2020, is open to criticism as it relates to its existing structure, and that out of a requirement of certainty and constitutionality, that we must cause amendments to the law. The amendments to the law that we propose are squarely rooted to the amendments now before us coming from the House. They concern in particular, and I'm going to refer to the sections now of the law as proposed to be amended, Section 6B, Section 6.1, Section 6 of the Parent Act, Section 6B as we propose to insert, Section 17, Section 17A, Section 19, and Section 20 of the Parent Law as it stands and as is proposed to be amended by the law. There is also a concern in relation to Section 4A as we propose to be inserted. So permit me to treat with that in the context of the amendments en masse, Clauses 2, 5, 6B, Roman 5, 7, and the preamble. Madam President, it is unconstitutional to oust the jurisdiction of the court. In legislation, there ought not to be a provision where the court's exercise of its jurisdiction is separated and stopped. That is called a breach of the separation of powers principle, which our Constitution recognizes ought not to happen. The parent law as it stands right now, Section 17 and Section 19, there is an ouster of the court's jurisdiction because it says that the evidence obtained in interception shall be admitted in court. It does not say that it may be admitted and leave it to the jurisdiction of the court to consider the admissibility of evidence. It says it shall be admitted. That means that the admissibility of the interception evidence itself is in problem. That means that the admissibility of interception evidence falls into the realm of hearsay issues. That means that the issue in the Constitution of a fair trial and due process falls into odium. And the amendment that we passed in this Senate, took to the House and passed with amendments and now come back here, are designed principally and fundamentally to remove the unconstitutionality of the 2010 law, which says that the court has no discretion. That is the major point in this aspect. The law, as we propose in Clause 4A, Section 4A that we propose to be inserted, says that the law applies to all evidence captured prior as we relate to communication data, intercepted material, and the general round of information, including stored data. Why? Because the law specifically asks us to look at the procedural amendment of law, not substantive amendment of law. The question is, do you need a 3/5 majority because of an allegation of retrospectivity? And the answer to that is that you do not have an issue of retrospectivity in the new Section 4E because you are not treating with a substantive law, you are treating with a procedure of admission of evidence. Stick a pin. The evidence is evidence which you could have obtained and did obtain. The law just recognizes that the evidence was obtained under existing law. What is the existing law? The existing law is the Proceeds of Crime Act, Sections 32 and 33, by which production orders can be obtained. The existing law is also to be found in the preliminary inquiries route, where we deal with the Indictable Offences Preliminary Inquiries Act, Section 5 of that Act, by which you can get a warrant to obtain communication data or stored data. And of course, it also includes the Indictable Offences Committal Proceedings Law, where Section 6 of that law allows for you to obtain warrants for interception, for obtaining evidence that has been intercepted, stored, or collected. So Section 4A, as we propose, does not require a 3/5 majority. It is a procedural amendment, and all that it does is to analyze and accept the existing law. The other sections of the law, which touch the removal of Clause 2 and the preamble, root themselves in the following principles. Section 4(1)A of the Constitution, that is due process of law. Section 4(1)B of the Constitution, protection of the law. Section 4(1)C, the right to private and family life. Section 4(1)B, the right of a fair trial. Madam President, what time is full time?
10 minutes past 11.
Much obliged. Let's see if we touch and concern any of these rights in the amendments that stand in the law that we already included here. So, put in summary, we are looking at whether one needs a special majority to do the following things. One, to intercept prisons' communication coming from a prisons, or communications between prisoners in a prison vehicle. Two, do you need a special majority to have evidence obtained by warrant, evidence that is not obtained by warrant, by way of interception, evidence that is obtained in stored communication or communication data, evidence that is sensitive in nature, sensitive evidence as defined in Section 17 and Section 19 of the Act, because the sensitivity is an important aspect of evidence. Do you need a special majority for those things? Whether you need a special majority is rooted in the test of proportionality. And there are two types of proportionality that one can consider. The vires, or the testing of the constitutionality, in the narrow sense of Trinidad and Tobago's looking at proportionality, is, have you a trifecta? Do you have a legitimate aim? Is there a rational connection that the amendments have to that legitimate aim? And is it proportionate? Do you go any further than you are required to go? There is, outside of Trinidad and Tobago, something called extended proportionality. And extended proportionality comes from a bank of cases that really are persuasive to us but don't apply to us. And extended proportionality is basically a small extension of the 3 prongs into 4 prongs. And we, Madam President, are absolutely certain that Section 6B1, 62H, 17A, 17.2B, and 19.1 of the law do not offend the extended proportionality test as set out in R.V. Oakes, in De Freitas, in that wider sense of Canadian jurisprudence, on a narrow sense of proportionality in Barry Francis, in Surat, in Northern Construction. On the 3-limb test, we are well within proportionality. Why? What is the legitimate aim? The legitimate aim is to balance the use of communication in criminality against the fight against criminality. Let me explain that. Prisoners are using communication in the prisons right now. People are being called upon to kill other people with those instructions coming from the prisons. We know that there is a criminality, and it's not unique to Trinidad and Tobago. It exists in other jurisdictions. What are the other jurisdictions? Canada, New Zealand, Australia, the United Kingdom, to name a few, apart from other parts of the Commonwealth. In other parts of the Commonwealth, is there a rational connection with the use of law to use evidence obtained from interception in a prison, warranted or unwarranted? In England, the United Kingdom sets out in a case called R.V. Bailey and in another case called R.V. Strange, or S-A-N-G-E, Sange. In R.V. Sange, those cases say that the common law in the United Kingdom is such that in the absence of a statutory prohibition, it does not matter how evidence is obtained. If even obtained illegally, the evidence can be used in a court of law, provided that the evidence is scrubbed by certain conditions. And we, in the conditions proposed in the legislation, achieve that balance by adding what we call the Bailey principles. And specifically, where we say that you are allowed to use evidence obtained by recordings in a prison van, or recordings in a prison, in other words, then bugging, because it's not interception of communication, because it's not over a telecommunications network, or if you are using intercepted communication over a telecoms network and you don't have a warrant, but you are exercising that interception pursuant to Section 6 of the Act. Section 6 has the fact that you can intercept if it's in the interest of national security, for the purpose of safeguarding the economic well-being of the state, for giving effect to mutual assistance, etc. The principles which are balanced against that, which are contained in the bill brought before us, are as follows. The rational connection, and whether we go any far than we ought to, are given as follows. Number 1, there must be a notice to prisoners. Number 2, there must be exception for legal professional privilege. That is in Section 6A, Section 6B. 3, you must preserve the sanctity of the interest of justice. And when you look to the interest of justice, you have to make sure that you are not going further or derogating from protections which the Constitution ought to accept. And what are those? Those are found, Madam Speaker, when you look to the amendments in clause 17 and 17A, we say the contents of communication, all of them, may be admitted into a court, provided, look at section 2C of 17, nothing was done to induce or trick the accused or defendant into saying something. The integrity of any recording or interception is sound. The use of the recording or interception device was proportionate to the gravity of the alleged or suspected offense. The use of the method was appropriately authorized by an officer independent of the investigation, and no recording or intercept of any legal, professional, privileged conversation took place in a place specified as being accepted. Those statutory anchorings of what we call the Bailey principles are there. But further, we give further protection. We say that for the disclosure of sensitive information, i.e., so as not to get into the dance of having evidence of intercept, inadmissible. It's inadmissible if you can't say who made it. The defense is entitled to probe the prosecution's case. They are entitled to ask questions such as, may I see the warrant? May I know who made the intercept? Can I know the identity of the officer who was sitting there? Can I know the workings of the system? Otherwise, the evidence falls into hearsay and will be excluded. So we say you can't simply say, as the 2010 law did, that you shall admit the evidence. No, sir. You will end up in an abuse of due process and a lack of a fair trial, and you must allow a judge to consider the admissibility of the evidence. So what we say, if you want to test that evidence, use a special advocate in a special measure where a judge will hear from the defense why that ought to happen, and you can protect the lives of people involved in the intercept. Because the last thing that you want to do is to expose the mechanisms of national security to the attacks and the murderous intent of criminals in this country. Is the special advocate known as a creature to common law? Yes. Is the special advocate known in the Commonwealth? Yes. Is special measure known in the Commonwealth? Yes. Has the European Court of Human Rights, has the Supreme Court in the United Kingdom, has the Privy Council upheld the position of special advocates and special measures? Yes. Has the European context and the English context told us that statutory enactment of special advocates and special measures is preferred over the common law? Yes. In a case using someone with my same name, in the Al-Rawi case, as it came forward, which concerned the admissibility of evidence in civil proceedings, the court then said that it is preferred that you engage in statutory enactment of what the common law permits in the criminal law into statute. So I put it this way, the proportionality of what we do, why we don't need a special majority, is anchored by the fact that the existing common law in criminal matters allows for special advocates if necessary, special procedures if necessary. We've gone further and we've said, let's take the advice in the Al-Rawi case, albeit on civil, and let's statutorily include that into the law. Clause section 20, as we propose it to be admitted, is another important safeguard, and that's when we get to the concept of the amendments proposed to section 20, where we introduce the concept of the public immunity and the public interest immunity. The public interest immunity is that you will not destroy evidence that is intercepted in the new subsection 9, information which may reveal the commission of other offenses by other people or which may jeopardize other inquiries shall not be disclosed to the accused, but shall be retained and be the subject of a public interest immunity application to the court by the prosecution. What does that mean? Can you potentially disturb the fair trial by not disclosing information to someone? Yes. But is it now balanced by due process? Yes, it is. Public interest immunity where you make an application, the prosecution must make an application to the court that there will be no disclosure. A court of law must consider that, and of course, you know you have the right of appeal all the way to the Privy Council in the round. Obviously, there's no procedural appeal in criminal matters, but it causes a ground of substantive appeal. So, Madam Speaker, what we have in the measures before us is a legitimate aim. We have a rational connection of the amendments to the legitimate aim. We go no further than the existing law, the Proceeds of Crime Act, the Indictable Offences Preliminary Inquiry Act, the Indictable Offences Committal Proceedings Act, the common law as is set out in the United Kingdom, the public interest immunity as is set out from the jurisprudence coming in the Commonwealth, from the European Court of Human Rights. All of these things say that we go no further and are proportionate in the measures. Now the question is, well, why pass law in this House with a preamble and with a requirement for a 3/5? And the answer to that is, we did so because we did not include, until we went to the House, the amendments that are proposed to Clause 6b, Roman 5, and Clause 7. We are not coming here today to simply strip this bill of a special majority. We are coming here to amend the bill which was passed in this House, in this Senate, with a special majority, amending it substantively in Clause 6b, Roman 5, and Clause 7. And what are we proposing to do there? We are proposing to avoid what Senior Counsel Hussain has said, the risk or the vulnerability to challenge on the basis that if those clauses, the new section 6b1 and 62h, which clauses 6 and 7 refer to, if those clauses are not further refined by measures, you can be open to risk. So we took Senior Counsel's advice, and we have specifically said that as it relates to prisoner intercept, if you look at Clause 6b, Roman 5, when we're in paragraph H, treating with amendments, paragraph H is where you introduce the fact that evidence in a prison can be used against you in a court of law. And what we say is, we ought to further narrow the protections by saying that that must be done in the interest of national security, for the prevention or detection of an offense under the Act, for which a penalty of conviction is more than 10 years, includes an offense where death, imprisonment of the remainder of natural life, or life imprisonment is a penalty fixed by law, for the purpose of safeguarding the economic well-being of the state, or for the purpose of giving effect to the provisions of any international mutual assistance agreement. In other words, then, we take the caution offered in Section 6 as it was passed in 2010, and we lift it specifically into prisoner intercepts. It's the same thing that we do in Clause 7 in the amendments to the new Section 6b, Roman 1. And when you look to the 6b, Roman 1, Madam President, 6b says, communications within a prison or a vehicle used may be recorded. So 6(2)H is interception of communication over a telecommunications network. 6b is recording. You're not using a telecommunications network, you are bugging the prison. And what we do is we improve the constitutionality by prescribing, as the amendments are circulated, to Clause 7 and to Clause 6, the interest of national security, etc. provisions that I've just read out. Put in a nutshell, therefore, this is not just simply removing the preamble and removing the 3/5 majority requirement. This is a substantive amendment to Clauses 6 and 7, where there may have been a risk of constitutional challenge on the basis of a sweeping inquiry or a risk of that. This can't just be a fishing expedition. A court must be jealous. A court must be careful in its position.
Attorney General, you have 5 more minutes.
Much obliged. A court must be careful in the admissibility of evidence. That evidence is now being done under the Bailey principles. 17 as amended 2A, 2B, 2C. It must be in the interest of justice. It must be proportionate. You cannot entrap people. You have to make sure that legal professional privilege is not an issue in the matter. And who decides this? A judge of the court decides this. Where does that fit in with the law as it stands in Trinidad and Tobago? Today, after decades, the Privy Council, Baroness Hale, paragraph 58 in Surat says, and I quote Surat because it is the law which is most supreme in our country right now. We're bound by the Privy Council's decision in these matters. Baroness Hale, in paragraph 58 of her judgment in Surat, specifically said, not every Section 4 right or Section 5 right, because there are a Section 5 right that you could contemplate, the right to a fair trial. Not every right is absolute. Secondly, Baroness Hale says, not every right that is touched upon or managed or even alleged to be intruded by law requires a Section 13 amendment. Because if you are within the parameters of a legitimate aim, a rational connection of the amendments to the legitimate aim, and if the measures are proportionate, and in particular if proportionality is fed by due process. And what is due process? It's not the Parliament saying so. It's not the executive saying so. It's a court of law under the separation of powers principle saying so. And Baroness Hale's decision in Surat, which guides us today, which has been upheld in Trinidad and Tobago Court of Appeal, in Northern Construction, and also in Barry Francis, and a number of other cases, Baroness Hale's decision, which is in our courts post-Surat, says that you can achieve these amendments provided you have proportionality. The amendments to Clause 6, the amendments to Clause 7 are there. Now, Madam President, I anticipate all kinds of allegations will be made. I want to put it straight today. We are, as a society, at war with criminality. The opposition in the House refused to support the amendments. I reminded the opposition of the risk of collapse of the entire Interception of Communication Act that they passed. They were not moved to save intercepted matters. They instead said that they preferred to have it collapse. They would not give the 3/5 majority support. And therefore, I remind honorable senators that when I piloted this bill and when we passed it in the Senate before it went to the House, I cautioned that the bill could be managed without a 3/5 majority, provided there were amendments made to the law. We made those amendments to the bill in the House of Representatives to Clause 6 and to Clause 7. And Madam President, I want to put it starkly as I wind up now. If this law does not pass, every matter which involves interception of communication evidence is at risk. Every single matter. And I, Madam President, on behalf of this government, will not watch the DPP cocky eye and tell him he doesn't know what he's saying. I will not watch Edward Jenkins QC cocky eye and tell him he does not know what he is doing. I will not watch Fayed Hussein Senior Counsel, eminent counsel, cocky eye and tell him his 88-page opinion does not make sense. I will not watch, Madam President, Baroness Hale or Mr. Justice of Appeal Nolan Barrow in Barry Francis, join this way to tell them that constitutionality is something that the opposition says. Madam President, I look forward to the contributions of honorable members, and I beg to move.
Honourable members, the question is that this Senate agree with the House in the amendments to clauses 2, 5, 6b, sub 5, 7, and the preamble of the Interception of Communications Amendment Bill 2020. Senator Mark.
Thank you. Thank you, Madam President. Madam President, before I go into these amendments, which are very dangerous to our democracy, I would like to have your ruling on Standing Order 72, subsection 4, that deals with bills that pass our House with a constitutional majority. And it is then revisited. We now are being called upon to revisit these amendments that we passed in this legislation, which is contrary to Standing Order 72(4) of our Standing Order. So I would like, before I speak, to get your ruling on this particular matter, because it is very, very serious.
Senator Mark, not that I'm aware that the fact that I'm allowing this debate is therefore consistent with Standing Order 72(4), because the Standing Order says the amendments, if in the opinion of the President appear whatever. Clearly, I'm allowing the debate, and I think the amendments can be put to the chamber.
Thank you very much, Madam President. Madam President, what is being attempted by this government is absolutely dangerous to our democracy, and we can use any argument in an effort to frustrate, to compromise, and to breach Section 4 of our Constitution. Because the key amendment to this list that I have before me, Madam President, is, in fact, the key amendments are, in fact, addressing the removal of the certificate that has been inserted when we debated this bill in the Senate. And what we have been given this morning is an Attorney General who is upset with the opposition. He cannot have his way when it comes to the rights and freedoms of the people as outlined in sections 4 and 5, when you are bringing measures to infringe and breach those rights. So the Attorney General decides to remove the special constitutional provision. Madam President, this is not a parlor. This is not a Mickey Mouse arrangement that we are dealing with. We are dealing with people's fundamental rights and freedoms. And like Hitler in Germany, you can use legal mechanisms in an effort to establish a dictatorship. And Madam President, we have to be very careful that we do not allow the government of Trinidad and Tobago to gut, slaughter, destroy our fundamental rights and freedoms. That is what is at stake here today. So I would like the Honorable Attorney General, we are not taking his word for anything. We would like the Attorney General of this country to come clean and to table now, today, before any other senator speaks, the constitutional opinion rendered to him and the government by Mr. Fayad Hossain. We cannot take for granted anything that is being said here by the government. We have to see what Fayad Hossain has said, Madam President. So I call on the Attorney General to make available promptly to this Senate so that the senators here can have access to this opinion. Madam President, I also would like the Attorney General to make available to this Parliament the CPC opinion. Because, Madam President, it is clear that the Chief Parliamentary Counsel would have recommended to the Attorney General and the government that this bill that came in its manifestation when we first debated it in the Senate would have had the opinion of the Chief Parliamentary Counsel, Mr. McIntyre. So I ask the Attorney General to table the Chief Parliamentary Counsel legal advice on the insertion of the 3/5 majority and why that insertion was necessary, Madam President. Madam President, the Attorney General in a statement a short while ago said he cannot face the DPP and he cannot face Edward Jenkins, SC, because they said all sorts of things about this bill that we have before us and what we have to do and what we don't have to do because things are unconstitutional. Madam President, that could not come in exchanges simply across the table. These would have come from these two illustrious legal luminaries via legal opinions. I call on the Attorney General of this country to table Roger Gaspard legal opinion and views on what he shared with us, that is the Honorable Attorney General, shared with us earlier. I also call on the Attorney General, Madam President, to make available the legal opinion showing the unconstitutionality of the parent legislation in the housing of the courts of this country by Mr. Edward Jenkins, SC. Madam President, we need to get these pieces before us because we are dealing with fundamental rights and freedoms of the citizenry of our country. And we just cannot take the word of the Attorney General. Madam President, I heard the Attorney General on a 95.5 FM program when this bill was passed in the House, 26 for, 6 against, Madam President. And you know what the Attorney General told Trinidad and Tobago? He has a surprise coming for the opposition in the other place. So, Madam President, the Attorney General of this country, from the word go, had an intention. And his intention, Madam President, from his public utterances, from his statement on the parliamentary records, and what he has just said a short while ago, the intention of the Attorney General was to gut, slaughter, and butcher and remove in the process the 3/5 majority that this bill requires for it to become law. That was the intention of the Attorney General, Madam President. Madam President, may I say very early that this invasion of the citizens' right to privacy is protected under our Constitution. The right to privacy is a fundamental human right guaranteed in our Constitution. And you cannot bring a bill here whose parents, the parent legislation of this piece of amendment that we have before us, required a special constitutional majority. And the reason, Madam President, the parent bill or act now required a special constitutional majority is because that bill, which is now an act, invaded the privacy of citizens in Trinidad and Tobago, and it violated Section 4 and 5 of the Constitution, Madam President. It was a clear intrusion of one's privacy rights, which is entrenched and enshrined in the Constitution. Madam President, the Attorney General, in these amendments that we are dealing with, would have gone further, where he has expanded the remit under this legislation. So not only is your privacy rights, Madam President, being affected by the amendments that we are dealing with and the removal of the sections 4 and 5, what is also at stake, Madam President, is property rights. Property rights are breached in this legislation that is before us. What is also at stake, Madam President, is our freedom of expression. That is also at risk and at stake with what the government is attempting to do here. This is an assault on our democracy. And every journalist, every member of the media, every media house in this country, whether you be print, radio, or you are television, Madam President, all of these media houses are going to be in trouble with this piece of legislation that we are being told does not infringe on the people's constitutional rights and freedoms. Madam President, what is also at stake in this legislation is what I call a Gestapo court. It is a court like secret. It's a secret court, Madam President.
Senator Mark, let me caution you a little bit, and perhaps all who are going to speak on this matter should listen. You're re-debating the entire bill. You need to confine your observations to the amendments that are before this House, okay?
May I seek your guidance again? The Attorney General of this country spoke. And Madam President, we are dealing with sections 4 and 5 of the Constitution.
And Senator Mark, I have given you tremendous leeway in your presentation thus far, but I think I have to caution you now, and for all those who are coming after, this is not a re-debate of the amendment bill.
Yes. President, I understand it is not a re-debate. Madam President, what I am saying in my response to the Attorney General in piloting these amendments is that when we look at what is being deleted, Madam President, and what the Attorney General is referring to as cases to bolster his submission here today, I am submitting to this Honorable Senate, Madam President, that there are many other cases that would bolster our submission to this Honorable Senate today. Because if you are going to remove these very important insertions as it relates to the certificate of the 3/5 majority, Madam President, may I remind this Honorable Senate through your good self that the United Kingdom and Trinidad and Tobago are two different societies when it comes, Madam President, to constitutional supremacy versus parliamentary supremacy. So when we go, Madam President, and we are being told that this has taken place in that society in the instance that we are discussing, I would like to bring to your attention, even in a country where you have a parliamentary supremacy, we have a case, Madam President, that bolster what I am advancing to tell you that the amendment that we are dealing with here and now to remove the 3/5 majority because of the invasion of your privacy through interception of your communication was in fact addressed sometime on the 13th of September of 2018 by the European Court of Human Rights when it issued a judgment in what is called Big Brother Watch and others versus the United Kingdom. Madam President, this was a judgment that dealt with Article 8, Article 10 of this convention, and it dealt with the government of the United Kingdom introducing and invading these spaces through mass electronic surveillance, the communications of citizens of the United Kingdom. And this matter went to the European Court of Human Rights, and it was struck down as illegal and unconstitutional in this very important case called Big Brother Watch and others versus the United Kingdom. And in this case, Madam President, which I am using to strengthen my opposition and our opposition to these amendments, the European Court of Justice indicated in their judgment that the law at that time, that is the RIPA, that is the almost a similar kind of legislation that we are dealing with now. They had it in the United Kingdom, and that was struck down, Madam President. They call it RIPA, Madam President. And the Court of Human Rights, the European Court of Human Rights, stated that this mass surveillance, as what we are getting involved in here now, violated, Madam President, the rights to privacy and freedom of expression of the citizens of the United Kingdom. And that law, Madam President, was struck down. It was said it was illegal, what they were doing. And what this government, Madam President, is seeking to do is exactly what was struck down as being illegal and unconstitutional, and it violated the human rights of the citizens of the United Kingdom to what is called their rights to privacy as well as their freedom of expression, Madam President. And Madam President, that is contained in what is called Article 8 of the Convention, the European Convention on Human Rights. And that convention states, Madam President, among other things, that everyone has the right to respect for his private and family life and his home and his correspondence. So what this is telling us, Madam President, is that yes, we agree that no right is absolute, Madam President. No right is absolute. But, Madam President, if you're going to abridge, if you're going to violate, if you are going to compromise and undermine the rights of our citizens, you must do it properly. Come with the requisite constitutional majority. And not because, Madam President, you don't have the 3/5 majority, because the people of this country voted the PNM as government with 23 seats and gave us 18. So, Madam President, you cannot be against the masses for their choice. But what the government is bent on doing, Madam President, is overturning or attempting to overturn the democratic decisions of the people to freely choose their members of parliament. That is what the government is attempting to do in these amendments here. Because to tell us today, Madam President, that because the opposition said they were not supporting the measure, you took a decision. I want to say you, Madam President, the Honorable Attorney General I'm speaking to. He took the decision, the Honorable Attorney General, to get what he called an independent legal advice from a gentleman whose name he has called. And up to now, Madam President, nobody in this Senate, I'm sure, Madam President, you have not seen that constitutional advice. And you are the presiding officer of this Honorable House. But we are being asked to go on what the Attorney General tells us and tell us who voted and who voted for and who voted against, that we must accept his word, Madam President. How can that be real? As I said, Madam President, this is not legal trickery that we are involved in here. We are not engaging in parlor politics. This is dealing with life and death. Madam President, when your communication is intercepted by someone who you don't know, Madam President, by some so-called authorized officer who you give no authority to record your conversation or to snatch your emails from your computer or your iPad so that they can macro or they can, in fact, view what you have said and what you have done and who you have communicated to and what you have said. Madam President, that is an invasion of one's privacy, Madam President. And the Attorney General knows it. He knows it, Madam President. But yet still he comes to this Parliament, Madam President, and giving the impression to this country and to this Honorable Senate that what he has done is constitutional, what is being proposed is proportional, what is being done is rational, what is being done is legitimate. Madam President, he's right, you know. He's right. This matter will not end here, Madam President. It will not end here. Madam President, we are a Senate, Madam President. We sat in this honorable chamber and we debated something, Madam President. We debated a bill. We are the decision makers of our Parliament. And therefore, I have the greatest respect for this constitutional lawyer called Mr. Fayed Hossain, or Hossain. I have the greatest respect for him. But, Madam President, can you expect us to abdicate our role as members of the Senate because one lawyer, one senior counsel, told the Attorney General, Madam President, that what we pass in this House is unconstitutional, literally. There is no need for a 3/5 majority. And therefore, we are being advised by the Attorney General, based on this gentleman's legal submission, that we, 31 of us, must bow to the superior wisdom.
Senator Mark,
Madam President.
you have 5 more minutes.
Yes, thank you very much, Madam President. So, Madam President, this is totally unacceptable. We cannot accept what the Attorney General is proposing. It is dangerous. And, Madam President, we cannot go further than these amendments. But, Madam President, I would like you to recognize an emerging trend when it comes to the government removing the special certified inserted constitutional 3/5 majority. This thing is now becoming a habit on the part of the Attorney General because he wants to have his own way, Madam President. He cannot stand opposition. Madam President?
Senator Mark, you're personalizing the Attorney. Yes.
The Honorable Attorney General, all right. I withdraw that. Madam President, so I have a few seconds left. What I would like to say, Madam President, we are not prepared on the opposition to accept blindly any submission made by any senior counsel. He could be the brightest bulb in Trinidad and Tobago. We are not prepared to accept blindly any submission made by this particular senior counsel, with the greatest respect. I can get a senior counsel right now, and I have one waiting to show that this measure that we are dealing with right now, Madam President, is unconstitutional and illegal. So, Madam President, having looked at these authorities, Madam President, I've looked at the one that I shared with you a short while ago. But, Madam President, apart from the one I just spoke to you about, there is another very important judgment that came out of the United Kingdom, and it dealt with what is called Big Brother Watch and Oz versus the United Kingdom. Madam President, that again, Madam President, dealt with the invasion through interception and a breakdown and a breach of human rights of the citizens of the United Kingdom. And again, Madam President, these are two important cases that we are bringing to your attention, Malone, as well as Big Brother Watch, to show you where the European Court of Human Rights, on the same interception of communication legislation, ruled that the law that invaded those citizens' private spaces were illegal and unconstitutional, Madam President. That happened in Europe. That happened in the European Court of Human Rights, Madam President. So, Madam President, we have provided to this honorable House our submission. We have given you references to two important cases, Malone and Big Brother. And, Madam President, one of the things I want to tell you in the United Kingdom that they did after those judgments, they have established, Madam President, what I call robust safeguards for the citizens of the United Kingdom against potential misuse and abuse of this Interception of Communication Act. In Trinidad and Tobago, Madam President, there is no safeguards put in the legislation that is now being reduced from a constitutional majority to a simple majority. There are no robust safeguards in place to protect journalists, to protect lawyers, to protect parliamentarians, Madam President. So, Madam President, I have made my case. We will not support these amendments that the government has tabled here. And I served notice on the AG. I told him yesterday, we are just awaiting them to sign off on this measure, and you'll meet us in court. I thank you, Madam President.
Senator Richards. Okay.
Thank you, Madam President, for recognizing me and allowing me to make a brief interjection into this bill, an act to amend the Interception of Communication Act 1508. And let me start by saying I'm certainly not an attorney at law, nor a constitutional expert in any way. So the issues that have arisen regarding this in terms of the delivery from the Honorable Attorney General, and certainly followed by Senator Mark, have raised quite a bit of interest in my mind. And the debate is specifically on clauses 2, 5, 6b, and 7, and of course the preamble. So I'll narrow my contribution to those. And I will say that the issue of the special majority needed or not, and the fact that the Attorney General went to quite pains to outline his argument in terms of the advice he's gotten from Mr. Fayyad Hussein, to me underscores what I would support in terms of Senator Mark's call for the opinion by Mr. Hussein to be provided for us to take up a more clinical look at it. Because we may have different interpretations, though I'm not an attorney, but certainly there are attorneys who may be willing to look at it and have a particular perspective on it because of the gravity with which the Honorable Attorney General presented that aspect in terms of his opinion on the relevant issue. So I'd petition respectfully if the Attorney General could also provide that so we could take a look at it in terms of making up our own minds as to whether we also interpret it in the same way. I will say, however, that in today's present context, even within the limited remit of the clauses that we're debating today, and the preamble 2, 5, 6b, and 7, the issue of privacy and privacy rights in the context of prison communication and inside of prisons and in prison vehicles is a no-brainer around the world. However, a lot of emphasis has been placed on the issues surrounding the warranted requirement, the requirement for warrants, in addition to the judicial overview and oversight in terms of applying to judges or judicial officers for those warrants, and very narrow remits upon which those warrants are presented or approved. In particular, the UK, I was able to get quite a bit of information, even in the first debate on this, which was much wider, in terms of the protections offered to the individuals who are the subject of these warrants in terms of the admissibility of the evidence, the duration of the warrants, which I haven't seen mentioned in these amendments. In many cases, they limit it to a specific time frame, 3 months or 6 months, because of the possibility for abuse in many jurisdictions. In addition to the protections offered to, and yes, I will declare my interest, media practice, journalists who, as we have mentioned before, should not be initiating communication to inmates inside of prisons or in vehicles, which could compromise the security arrangements for keeping those inmates, because they may be unwittingly drawn into communication that may be facilitating criminal activity without even knowing it. So I'm totally on board with the protections where that is concerned. But there must be specific and stated exemptions for journalists working in the public interest who may be working, who may receive information, who may not have solicited or initiated that information, working to unearth atrocities inside prison walls or inside of prison vehicles where we've known that atrocities take place. We've heard several allegations about prisoners or inmates being beaten inside of prison vehicles and behind prison walls. So I think it's quite justifiable that in some instances, with the proper oversight, that journalists should have certain protections when it comes to communications that come to them in a legitimate form, not breaking the law, not they initiating or breaking the law, but certainly in the public interest. And of course, the issue which is covered in the bill in terms of legal professional privilege. There's also another overriding issue when it comes to privacy, and that's the commercial aspect of it. And I know my colleague, Senator Vieira, is more of an expert. I'm not an expert. Is an expert in this regard, where trade secrets are concerned, and have we gone far enough in terms of that? And I hope the Attorney General can address that in terms of his winding up, when he is presenting his winding up. And also the issue of, even in these clauses that we're debating today, what is described in best practice, the Council for Europe, Budapest Convention on Cybercrime and International and Regional Trends and Best Practices, is the issues related to communication involving data and information about children, and how that should be treated with and dealt with in terms of the protection. I know we have our Children's Act, but when it comes to information from inmates that may be intercepted, that may involve information about their children, and that information may be sensitive because they're communicating, though illegally outside, that information may be captured by the interceptions, and that should be protected in an outright manner in the clauses in the bill. And I have not seen that even in wider than the 2, 5, 6B, and 7 as outlined in this proposal.
So, Senator Richards, just based on what you just said, I really have to caution that we don't go beyond the parameters of the amendments that are before us.
I'm guided, Madam President. Thank you. In specifically dealing with 6B in the revised presentation today, and I really have to say that I have some concern with and I'm quoting, communication within a prison or vehicle used to transport may be recorded by an authorized officer. And I didn't see a reference as to the rank of the officer. And I know there are other parts of the bill that would have identified the Commissioner of Prisons identifying that officer. But I think it should be made clearer. Unless I missed it, I apologize if I did. And yes, and in Part 46B4, notwithstanding any law to the contrary, communication referred to in subsection 1 that are not subject to legal professional privilege unless the communication occurs within such places within a prison that may be specified by the minister. And I'm trying to figure out what the intention is there. And I think, while, as Senator Mark indicated, no right is absolute, I think professional legal privilege, unless it seeks to break, it's identified as breaking the law, should be protected zealously. In conclusion, Madam President, I think the overriding comfort I would have with this, even in the absence of clarity on whether or not a 3/5 majority is required, is the provisions that have been outlined where judicial officer and warrant are mandatory. And I would be very loath to commend this to my approval. In the absence of those, they are provided for in some measure, and I'm hoping the Attorney General can elucidate that more upon his winding up. What circumstances is he referring to? Because he mentioned it in his delivery, in terms of he mentioned warranted or unwarranted, and what circumstances would be unwarranted. And if he could comment on the retroactivity of this in the interest of the cases that he cited in a cursory manner that may or may not collapse in the absence of this kind of legislation. So those are the kinds of clarity, and once again I petition for if he could find approval in providing the document that Mr. Hussein gave his opinion on. And with those few words, Madam President, I thank you.
Senator Dial Singh.
Thank you, Madam President, for allowing me to partake in this debate. The bill, an act to amend the Interception of Communications Act, Chapter 15.08.
Singh, just because I don't want your contribution to go off, we're actually just debating the amendments set before us to the bill. We're not going into a full debate. We did that already. Okay?
Thank you, Madam President. Madam President, I must say that even though we went through this debate recently, and there are new parts of this bill that the Attorney General brought to the front, I am saying, Madam, that yes, as the Attorney General did mention, there is a need for this bill. There's a need for the interception. As you see, worldwide, globally, there was the disclosure by the Minister of National Security before the fact that even in United States, certain areas, there was a need to go after the contraband phone use in prison. And even there were problems to cement this piece of legislation, to attack this problem. So as I look at this new pieces here, I realize it's really trying to cement what we did before, to ensure that the Attorney General mentioned the fact that he has gotten certain opinions from esteemed attorneys, and because of that opinion, there may be some loopholes or some areas where there is sections which may be challenged. So it seems that Clause 6 and 7, we are looking to see how could we cement what was passed before. And it reminded me, Madam President, as a cricketer who came out to bat. And when he's batting, he realized he forgot his pads. So very quickly, you have to put your pad on to prevent any sort of damage. So I'm saying that in this case, we hope that these pieces that we are looking to amend will, in fact, assist us in managing this bill. Madam President, I must say, I looked at the fact that the interest of public safety and security is needed, and the balance between the public interest and safety, and you're balancing that with the privacy issues, and we saw the need for that. I listened to the contribution of Senator Mark, where he made mention that sometimes it may be like he mentioned Hitler, and the fact is there is a concern that the legislation may, lead to some abuse of power. There may be political mischief afoot, and he did mention to that. And I quote Lord Brown Wilkinson, who even mentioned the dossier of private information is the badge of the totalitarian state. So therefore, there are concerns that we may not be able to challenge this bill if these pieces of legislation is passed today. It may further give a hindrance to persons out there who's waiting in the wings to say, well, this piece of legislation is really a piece of legislation that goes against our Constitution. Be it as it may, the fact that the AG went at pains to say that, you know, there are safeguards in this legislation, Madam, safeguards, and he made mention to the fact that there's a judge who would have to hear this evidence to see if it's admissible. He made mention to the fact that police officers would be, you know, evidence gotten by police officers, and I heard my fellow senator, independent senator, Mr. Richards, made mention to the fact what rank of police officers. So even though the Attorney General gets comfort that here it's a judge now going to look at this evidence, yes, that it is police officers, and we need to clarify the rank, as Mr. Richards said, I still am not getting comfort in this matter. Because, Madam, if you realize, if we are thinking the logic goes political mischief, we had someone in the past who was a judge 1 week and then ended up being a member of Parliament. We had police officers up to recently who have seen high ranks who have ended up putting themselves up candidates for political party. So you may have the concept there that yes, you have safeguards in, but then those persons there who are there to administer this law, they may, I mean, in the past have shown that questions arise about those persons, even when they were in office, may have political ambition and may misuse this piece of legislation. So we have to really ensure that this piece of legislation is not misused by persons who we think are independent and really didn't show their spots yet. So I look at the fact that under Section 6A, that the idea that prisoners would now have to be notified that they would be under surveillance, that is good law. You have to notify me that if I'm in a prison, my phone may be used as evidence. But what I'm saying, even this, you know, if I'm now in prison, Madam, President, I would now use a new way to get my information out, because there I am totally now warned and forewarned about this. So therefore, it could be passed in legislation that maybe redundant in the sense that...
Senator, forgive me, but I need to caution you to look at the amendments that are before us and not to go into the full extent of the amendment bill, which has already been passed, sent to the other place, and is back here, limited to the amendments.
Thank you, Madam President. But, Madam President, I am just responding to the fact now that the AG made mention about the special advocate, that he made mention to the fact that that was a safety, a safeguard, a measure, and clause 16 and 17A looks at the safeguard. So therefore, if we are looking in response to what the AG said this morning about the special advocate, Madam President, I'm thinking we have that person in that position. That person is a safeguard, because we made mention of the safeguards. That person actually would be the person who would be appointed by the court. That person, usually under the British system, would be a person under 20 years experience. And also, what I would probably like from the Attorney General, even though he mentioned the fact that the special advocate is there to assist the prisoner, I am thinking that we would need a little clarification of the fact that where would the monies come from to help to hire this special advocate, because we already see there are deficiencies.
And Senator Dialsing, no, I don't think that at all, even though the Attorney General may have made mention to certain things, the fact of the matter is, in your contribution, you really have to focus on the particular amendments and not raise matters that are extraneous now to the amendments. Okay?
Thank you, Madam President. So, Madam President, I would like to make mention to the fact that according to the clause 4A, we see the need in terms of the criminal proceedings, the Extradition Act, the Anti-Terrorism Act, the civil aspect for forfeiture. We saw that need for that. We saw the fact that even under the civil proceedings, Madam President, you do have the the interception of communications already there. So I'm saying even though this seeks to introduce areas where we could intercept communication, under the civil proceeding it was there already. And I'm just thinking this is the piece of legislation that and even done without warrant. So I'm seeing even under section 2B, the interception of communication, you already have that without a warrant, and this just gives a furtherance to the ability now to go after these criminals, go after the evidence that they may have. Retroactivity is something that I think was made mention by Senator Mark this morning, and this is again, I think the Attorney General will probably expand on that. So I looked at the fact that the safeguards were there, Madam, in 17AB, 19, 6B1, 62B, the admissibility of evidence, you know, all these safeguards are there. And even when I looked at the fact that the Attorney General mentioned the fact that he actually sought to, prevent the oyster of the courts in certain matters in this legislation. So all those are aspects I think he's trying to tie in. All those are matters I think he wants us to try and see if we could plug this legislation there, this legislation which I have supported before. And as I sit here, I am saying that if, in a sense, this other pieces of legislation could serve to plug whatever loopholes we had to at least, go after the criminal element, or go after the cases that we have that we are unable to get at due to help the public interest. I'm saying in such a manner, I would want to support it. However, I am still to listen to the contribution to the other members to see if there's any sort of a danger in the retroactivity aspect, if it could be used as political mischief by the present regime, and what safeguards could be put into place. So I'm still there waiting to listen to this debate, and I'm saying, Madam President, I thank you for allowing me to contribute.
Minister of Agriculture, Lands. Minister of Agriculture, Lands and Fisheries.
Thank you very much, Madam President, for the opportunity to contribute to this debate. Madam President, I anticipated that my colleagues would have some difficulty in being able to focus on the matter that is before us, and that essentially relates to 5 amendments made in the House of Representatives. I want to address 2 areas in particular, Madam President. The first is to say, my colleague Senator Mark, in his contribution, of course, Madam President, Senator Mark's contribution are now essentially comprised of the same elements over and over. We always hear about infringement, treaty obligations, human rights violations, constitutional right violations, and today we heard about property rights and freedom of expression, and it usually ends out with the Gestapo allegation and the overthrowing of the democratic right. And in doing that in 30 minutes, Madam President, he's found little or no opportunity to focus on the amendments which have come from the House. He's also, Madam President, raised a question on the propriety of what is before us and what we are debating. And I just want, Madam President, to refer to 4 of the standing orders which are relevant to us. The first is Standing Order 32, which deals with the business which may be conducted by this Senate, and sets out in Standing Order 32, Madam President, certain exceptions. So there are exceptions to what the Senate can do. And the most famous exception, of course, is a debate on the money bill, on a money bill. So there is nothing before us today that offends Standing Order 32. The second standing order I would refer to, Madam President, is Standing Order 35. And the matter of the approval of a motion for debate is a matter for the presiding officer. The standing order is very clear that it is the President that determines or approves a motion for debate. And we are here on account of that an approval. Standing Order 61 is specific to bills brought from the House where that bill was laid and debated in that House. And Standing Order 61 does not apply to this bill. This bill was laid, debated, passed with the requisite majority, and referred to the House for debate there. But most importantly, Madam President, is Standing Order 72. And Standing Order 72 is a standing order to guide us on what we should be doing in this House today. And Standing Order 72 requires us to consider the amendments which were made in the House. So this is not a brand new debate on what we debated before. You don't get a second bite of the cherry. And I don't anticipate anything different from my friends on the opposition bench. They voted against the original bill. So we do not expect support on this one in any form or fashion. But we expect knowledge, understanding, appreciation, and most importantly, respect for the standing orders. And Madam President, Standing Order 72.3 is very specific when it says that when the Senate proceeds on the consideration of the House amendments, each amendment would be considered. And it is only the amendments which ought to be considered. And if the President believes that those amendments should be considered immediately, then that's a decision for the presiding officer. And if the belief is that it should be done on a later date, then that's a decision. So we are properly here in accordance with the decision to proceed in relation to the amendments brought from the House. And there is another element, Madam President, which I consider to be equally important, and that is the provision in Standing Order 72.4. And 72.4 makes it clear. In fact, 72.4 recognizes the possibility that in a bill leaving this House and going to the other place, the House itself may make amendments which are inconsistent with the work of the Senate. The standing orders recognize that that is a risk, that the House, in conducting its duties in relation to a bill, may act in a manner which is inconsistent. And 72.4 makes it clear that it is for the presiding officer, the President, where it appears in the opinion of the President that amendments made in the House are inconsistent with sections 13 and 54 of the Constitution and inconsistent with the work of the Senate, those amendments may not be put to the Senate. So, Madam President, the combination of Standing Orders 32, 35, 61, 72, and in particular 74.4 tells me and tells us on this side that these amendments are properly before this House for debate today, and they relate to 5 matters addressed in the House. Madam President, the second area I would address is in relation to the amendments themselves. And I've listened very carefully. Now, let me dismiss the notion of the amendment which is listed as number 5, which is the insertion of a definition. I do not believe that that is objectionable in any form. Proceedings means proceedings referred to in section 4A. And that is simply because from time to time, we have to define, especially since we are dealing with so much criminal law legislation, that we have to define what is covered and what is not covered. In some cases, we have to be specific. And you would see, even in the original bill, you would see where we had to define what are things included in proceedings. So I do not consider that to be objectionable. I did not hear, Madam President, so far, anyone recognizing the importance of what is proposed in relation to 6BV and 7. And that, Madam President, is very important because Senator Mark, and I'm sure others to come, make it sound as though we've stripped, the word stripped has been used, stripped the constitutional majority requirement and violated, in the words of Senator Mark, we've infringed treaty obligation, human rights, and all of those things. Madam President, what is proposed is 6BV and 7 are really constitutional safeguards which we did not have previously in the bill, in the version that went to the House. And Senator Richards touched on it, but in a different way, by asking about the rank of the authorized officers. But I would say to Senator Richards, the issue of authorized officer would have been addressed in the original bill which we passed itself. But more importantly, the words which flow after authorized officers inserted in the other place are words that are vital to the safeguard of constitutional rights insofar as we are dealing with the important issue of interception of communication. Because, Madam President, I have not heard, apart from the opposition, I have not heard, I wouldn't say significant, I have not heard objection to this issue of interception of communication. Because let us not fool ourselves. The prisoners are communicating. And I remember on the debate in the original bill, I remember referring to a Guardian newspaper article that has not been contradicted by anyone. And in relation to 6B4, 6B5 and the proposed amendment, I want to say this. That Guardian article, Madam President, set out in detail communications that apparently or allegedly took place between a prisoner and somebody on the outside, which the article alleges led to the execution of the lady who was holding her son's hand outside the graduation in Santa Cruz. That is what the Guardian said, and I followed very closely to this day, looking for contradictions or denials and so on, and I have not seen anything. So it should be taken as fact. And this matter of, I have listened to everybody talk about constitutional rights and infringements and so on, and nobody would descend to what is a simple fact. Communication devices are not allowed in the prison. So while you are busy, and I made the point in the debate on the original bill.
And Minister, I have to interrupt you here just to say that let us not re-debate. Yes. Let us be specific to the amendments at hand.
Very much, Madam President. Madam President, what has happened in the amendment to 6B5 is that the safeguards have been inserted where the authorized officer, the person who can intercept a communication from or to a prison vehicle or from a to the prison itself, can only do so in prescribed circumstances which did not exist in the bill that left the Senate. And those are important safeguards in the interest of national security, for the purpose of prevention or detection of an offense, for the purpose of safeguarding the economic well-being of the state, or for the purpose of giving effect to the provisions of any international mutual assistance agreement. Those are 4 important safeguards, so it's not going to be the authorized officer is not going to be able to intercept communication from or to a prison or from to a prison vehicle, except in those circumstances which are prescribed. The other main amendment, Madam President, comes in the proposed 7. And again, similarly, what left this House to go to the other place did not have that safeguard, which is similar to what I just described, except that the communications being addressed in our proposed 6B1, that communication is communication within a prison vehicle or within a prison. And again, I would say, Madam President, in relation to those wailing and crying for constitutional rights of the prisoners, that you should not have a communication device in a prison vehicle or in the prison. The only communication device you should have in a prison vehicle, I remember when I was a much younger lawyer walking to the court, and the prisoners will be screaming and calling out from the prison van. That's the only communication device. So, 7, the proposed insertion of language in 6B1 circumscribes the power of the authorized officer in relation to communications within the prison and communications within the prison vehicle. And lastly, Madam President, consequential amendment is the deletion of the preamble, which comes because the removal of the language which we normally insert when a constitutional majority is required has been removed on account of the deletion of Clause 2 and the replacement of language relating to the proclamation.
You have 5 more minutes.
Madam President, Senator Richards touched on legal profession privilege, and he used the expression, it needs to be protected zealously. I have expressed my own opinion on this issue of legal profession privilege. It is something that was once described, it was one of those cloistered virtues that we call them in the profession, sacrosanct, and it's been chipped and chipped away, and rightfully so. And Madam President, it's no secret that the Commissioner of Police and other persons in the society have talked about the prospect, the possibility of officers of the court, including attorneys, being involved in conduct which are inconsistent with what the profession requires of them. And on account of that, even in relation to communications between attorney and client, there have been instances in the law where that professional privilege has been interfered with. Of course, we'll have different opinions of it. I have mine, but Senator Richards talks about protecting zealously. I would just say protection to the extent that it needs to be protected so that a client can have access to counsel and be provided with the professional advice that a client requires. Madam President, I thank you very much.
Very much, Madam President, for acknowledging me and allowing me to rise in this August chamber to debate on this motion, which is a list of amendments that were made in the House of Representatives to the Interception of Communication Amendment Bill 2020. And Madam President, normally I listen attentively to the Minister of Agriculture, Lands and Fisheries when he debates in this Parliament. But today, I must say, Madam President, that he has not lived up to his standards that he usually debates in. I was very disappointed in that he made very light of our argument on this side with respect to the protection of constitutional rights and privileges, especially having spent several years in Canada, where especially rights of privacy that we're going to be dealing with here now is being affected. And Madam President, I know that this debate is very limited in scope, and from the outset, I will indicate that my presentation will only be restricted to the special majority requirement and the removal of same with respect to this amendment bill. And I am going to look at it from the angle of the jurisprudence in which the Attorney General would have given to this particular Senate in absence of the legal opinion that he didn't provide to us by Mr. Hussein, Senior Counsel. And Madam President, just to address a few points in which the Attorney General had made in terms of the purpose of this particular bill. The purpose seems that the goalpost has been shifting from the time the bill was laid. In that, we were told that the legislative aim when we are addressing proportionality, firstly, was that we need to stop communication in the prisons. Now, secondly, we're now hearing a new argument that this bill is required to protect intercepted communication based on representation made to the Attorney General by the Director of Public Prosecutions and Mr. Jenkins. Again, we don't have the luxury of those communication in this Senate. So we are debating this blindly based on the representation given to us by the Attorney General. Madam President, I want to look at that argument that this is to protect the intercepted communication. And the Attorney General spoke of the directory admissibility of the evidence with respect to intercepted communication found at clause 17 of the bill, which he said that this bill requires passage. Now, 2 points on that, Madam President, is that one, the Parent Act was passed with a constitutional majority, so it is even more protected in that Parent Act as compared to this particular amendment bill that we're doing. And secondly, there was no amendment made to that particular section which requires a mandatory admissibility of the evidence, because it still reads that the evidence shall be admissible. So that particular argument by the Attorney General doesn't hold water with me, Madam President. Secondly, we're looking at the other arguments that the Attorney General would have used in terms of Surat, Northern Construction, and R.V. Oaks. Now, Madam President, I looked at those cases, but I have also looked at the case of Hines against the Queen, and I have also looked at the case of the Barry Francis case, the minority judgment in the Francis against the State case. And I want to spend some time on that particular point, Madam President, because I think it's very critical that we look at the context of this particular debate with Surat, because the Attorney General used Surat as a constitutional springboard in which to bolster this particular amendment in terms of removing the requirement for a special majority. Now, our Constitution at Section 4 and 5 provides for several rights, privileges, and freedoms that are constitutionally enshrined and protected. At Section 13, the Constitution outlines the procedure that if it is the will of the Parliament, the will of the people, to infringe or abrogate those rights, then the Parliament must pass that particular piece of legislation with a 3/5 majority as outlined in Section 13 of the Constitution. Now, what does the case of Surat say? The case of Surat said that not all rights are absolute rights, that they are qualified rights. And Baroness Hale in that judgment indicated that notwithstanding a particular piece of legislation, in that case they were looking at the Equals Opportunity Act, was not passed with a special majority. If it is proportional, then it can still meet constitutional muster and be protected from being struck down by the courts. That is what the Privy Council said in the case of Surat. And that is the principle in which the Attorney General is using in order to bolster this particular amendment. Now, Madam President, in the case of Barry Francis against the state, there's a majority decision given, and they followed the principles as outlined in Surat, that there is no requirement in terms of passing the legislation with a 3/5 majority for it to be immune from constitutional challenge. But the minority judgment, Madam President, is very important in that case, because the two judges that sat in that minority judgment.
Senator Hussain, you're taking me back to my university days, and that's way back. And you're actually doing a better job of making me understand some aspects of the law. But I need you to really, in presenting what you're presenting, you need to tailor it to the amendments. Okay? You need to get it very quickly, what you're saying about the amendments.
Madam President, the argument that I want to present is that the case of Surat is not applicable in this case, which the principle used by the Attorney General in bolstering these amendments. And I say that because Surat cannot always be used in order to bring legislation to this Parliament without the use of a special majority. Because at Section 13 of the Constitution, which is the supreme law of Trinidad and Tobago and not the Parliament, we are required to follow prescriptively what the Constitution outlines. So what did Justice of Appeal Jamada at that time and the Chief Justice said? They said that Surat cannot always be applicable in Trinidad and Tobago. They distinguished Surat on various grounds, Madam President, in terms of, they spoke of Lady Hale didn't give any consideration to the context, text, policy, or precedent of Trinidad and Tobago. Now, it's the same thing here, because we are asking the Senate that passed the bill with a special majority to now come and agree to the removal of that special majority. No amendments were put in place in order to remove the offending provisions of the bill, but now we're asked to approve that the bill that the Attorney General and the government declared that was unconstitutional is somehow now constitutional. And that is what I'm saying, that we cannot just apply these principles willy-nilly. You have to make distinctions and you have to look at the law, because Surat is not the only case. You have another case called, Madam President, the Hines against the Queen, which Surat only looked at for the principle of separation of powers and not with respect to special majorities. In this case, Madam President, again, we have to make a distinction between rights that we just affect as compared to rights that we derogate from. And my submission is, Madam President, based on what is being proposed, we are derogating from rights. In Surat, they spoke about affecting rights. That is the distinction that the Chief Justice and Justice of Appeal Jamada made in the Barry Francis case. And they also went on to say, Madam President, that to equate proportionality with consistency of legislation in terms of 415, you can't do that, because you have Section 13 of the Constitution, which you are required to follow. Now, Madam President, I want to look at...
Senator Hussain, so you've given all of that information, analysis. Please apply it to the bill. Tell me, at least, why what you're saying is relevant to these matters at hand.
The relevance of this, Madam President, is to say, firstly, Surat is not applicable. I'm using the argument of Hines against the Queen, whereby the Privy Council said that we have to pass the legislation with a special majority. Now, let us just presume that if this bill is challenged, that the court does not accept the argument of the Section 13 majority, and they go on to follow the principles as outlined in Surat. Just as the Attorney General did the balancing exercise using the principles as outlined in the Northern construction case, I too would like to balance that. And I make the submission to you and the honorable senators in this House is that this legislation is not proportional. It's not proportional to the legislative aims. The Attorney General argued otherwise. Now, the three principles we have to look at when exercising.
Senator Hussain, I know you have limited time, but simply saying that you are still continuing your little mini lecture on law. What in clause 256B57, please tell me, relate all that you're saying to these clauses. Please, Senator Hussain.
Madam President, I am outlining the law. I'm going to then apply the law to the facts, and then I'm going to conclude. And Madam President, if I'm given the opportunity, the legislative objective of the bill, as outlined by the Attorney General, which is the first prong that we examine in the Northern construction case, what is the objective? The objective is for national security. It is a fight against criminality. It is to stop communication between prisoners and the outside world. So we're good with the objectives. Let's look at the measures, because Northern construction asks us to look at the measures being used. The measures being proposed by the bill are warrantless communication, warrantless interception. You have the use of special advocates. You have the intrusion of privacy in terms of persons looking at private communication. So let us also examine the rights that are going.
Senator Hussain, okay, you need to be specific to the amendments that are at hand, please.
With all due respect, I don't know if I'm making myself clear enough.
I always get nervous when a senator starts by saying with all due respect. I hear you. I'm asking you to tighten up your contribution.
I'm not disobeying your ruling. Just permit me, if I may explain, that in order to determine proportionality, we have to examine what is being proposed. If I am standing here and just saying that the measures are not proportional, I'm not doing my job. What I'm saying is that you have to look at what is being proposed in the legislation, measure that against the legislative aim in order to determine the proportionality. And that is what I'm doing. I'm looking at all of the measures outlined very briefly and succinctly because I do not want to go back into the second reading of this bill. And that is what I'm doing. And I also want to look at the rights that are going to be touched, because it's not one right is being breached. You have the right to privacy. It's a section 4 and 5 right. You have the right to a fair hearing. You have the right to protection of law. You have the right to retain and instruct without delay a legal advisor of his own choice and to hold communication with him. Now, Madam President, those are about 5 rights that I just indicated there that will be breached with this particular piece of law. And then you're going to measure that now by saying this is proportional to the legislative aim. Madam President, there were over, and I'm just going to give one example, 500,000 intercepts in 1 year with 5 arrests. So the question is whether or not we're taking a hammer to kill an ant, because that is the balancing exercise we have to perform. Whether or not what we're doing here is more than necessary. Let's look at whether or not it's more than necessary. Can we find another way to stop communication in the prisons? Yes. Is this bill only applying to criminals? No. Is this bill applying to every citizen of Trinidad and Tobago? Yes. So you cannot say your legislative aim when looking at proportionality is to deal with the prisoners, when in fact this bill intercepts communication from every single citizen without a warrant and is now being made admissible in a court of law. When you look at the requirements of a warrant, you have to show the court that it's the port of last call. You must have exhausted all other investigative measures. This is now going to be the first port of call. So it's a direct intrusion in terms of the rights, and that is why I'm asking that this bill should not, the special majority should not have been removed because it is an unconstitutional piece of legislation, Madam President.
You have 5 more minutes.
Thank you. So just to recap, 1, Surat doesn't apply because we're looking at the Barry Francis case. And even if Surat applies, Madam President, we're saying that the legislative measures are too heavy in order to attain the legislative aim, Madam President. And these are the facts that we have to look at. This Parliament cannot and will not be used as the cabinet. That is why this is a defining moment in our history, Madam President, where we are standing here, where a bill left here with a constitutional majority and came back to us with a simple majority. Madam President, this government is out of control. This is not a democratic state anymore. This is turning into a dictatorship, Madam President. We have constitutional protections and privileges here that are being ignored by the executive. And you cannot expect us here in the opposition who took an oath of office to allow this to happen, Madam President. And that is why there's also an additional layer, so that in the event that this bill leaves here and we are saying that it is intruding on constitutional rights of ordinary citizens, the court, Madam President, will have to make the ultimate determination on whether or not this particular piece of legislation is constitutional. And with these few words, Madam President, I thank you very much.
Senator Vera.
Thank you, Madam President. Madam President, we are now in the extraordinary situation of trying to salvage necessary and important legislation on a simple majority. It would have been really nice to have had the 3/5 majority needed, but since that is not the case, the question for us today is whether the amendments brought, whether the bill will hold water without the 3/5 majority. And I think the answer to that is going to turn on whether the rights enshrined at Section 4 are being abrogated or not. Now, the amendments really are dealing in the main with the communications of prisoners, prisoner interceptions. It's trite, but worth repeating, that prisoners' rights are already curtailed when they are in prison. Their liberty and freedom, family life, and privacy. The question is, if we as a Senate are aware that prisoners have and are hatching plans to commit nefarious crimes, including murder, can we ignore the pleas of the DPP, the pleas of the law enforcement, the pleas of government to try and bring in legislative measures that will address that concern? Should prisoners have an expectation of privacy when caught out in conspiracies to commit crime? Should prisoners have an expectation of privacy when making surreptitious and unlawful communications, whether by phone or by text? When prisoners are aware that their communications are being monitored, should there be an expectation of privacy? I think not. As far as I'm concerned, prisoners' rights were restricted by due process of law, and I don't see any deprivation of the fundamental rights and freedoms that would require a 3/5 majority where that is concerned. Now, the other point that has come up is really, are citizens at large also going to be affected? Well, the amendments and the parent law speak to the rights of privacy and the interest of national security. Well, I have no doubt about it. We are a country that are in the throes of serious crime. This very parliament has been the subject of terrorist activity. We know of organized crime in all its forms and fashions. We know of eminent people, past members of this Senate, who've been killed down, gunned down, assassinated by organized crime. Are we to turn blindly and say, well, the rights of the individual trump all of this? National security must take a backseat to that? The Constitution speaks of the right of the individual to equality before the law and the protection of the law. And I think that is what I'm going to focus on, because at the end of the day, it's always going to be about a balancing of rights. But what really reigns supreme is the Constitution and the rule of law. Now, another thing. When the Constitution was drafted in the 1960s, rights of privacy operated in an analog world. We didn't have, the framers of the Constitution didn't anticipate all these new technologies. They didn't, when they talked about issuing warrants, they were issuing warrants in a physical world. They were not anticipating about information not being stored in a desk or drawer, but in the cloud. So how do we translate, how do we adapt those values in this brave new world? This is an evolving situation. You can't read the Constitution like it's some sort of sterile slab of stone. It sets out key principles, but it's a living, breathing document. It evolves. We have to evolve with the needs and circumstances of the time. I've said it before, and I say it again. In Trinidad and Tobago, we don't have a privacy law. The protections for privacy bind government, but they do not protect, they don't bind private citizens. I have seen this legislation actually as a step in the right direction by providing some sorts of privacy in the digital age. And again, we're talking about privacy, but privacy is not an abstract thing. When we come into this building and they scan your bag, or you go into the airport and they pat you down and they search you, when we are driving on public roads and there are cameras everywhere, the fact of the matter is privacy in the 21st century has been very impeded when it comes to movement in public places and spaces. So again, what is necessary? What is proportionate? Coming back to the point of this legislation, what is really an issue here? We know the technology is already in use. Don't have any doubt that they're surveilling, they're eavesdropping, they're listening, they're taping, whoever they want to tape. The question is really about whether that information can be used in evidence. That's what this is about. It's about the admissibility of evidence. And again, I come back to the rule of law point, that what this legislation is about setting up a framework for the other power in the separation of powers, for the judiciary to weigh and consider whether this is admissible evidence or not. We come back to the equality of protection, the equality under the rule of law. I think that these amendments are trying to find the balance between private rights and the need to combat criminality and terrorism. And again, it's going to be an evolving situation. What kind of surveillance activity should trigger privacy protection? There is a separation of powers. Our function is to bring the laws. That's not for the courts. The court's function is to interpret and to give enacted laws their fair meaning, whether those laws are ultra-virus or virus. It is for the courts to make those determinations, but it is for us to set out the framework for the courts to consider and rule on whether rights have been affected or not. I see the provision of the special advocate as actually an attempt to balance competing and complex interests in a very novel and emerging situation with new technologies, serious crimes. How do you weigh the rights of the individual against the national interest? Ultimately, this is a rule of law issue for me. I think the amendments seek to strike a fair balance between the interests of national security and crime prevention on the one hand and the privacy of citizens on the other. The rights enshrined in the Constitution set out fundamental principles, but they're not cast in stone. They allow for flexibility under the rule of law and the due process of law. We bring the laws, the courts will consider whether the evidence is admissible or not. This legislation is subject to, and it's all about the rule of law. Procedures to safeguard and protect the rights of the individual at trial, the admissibility of evidence, and for tribunals to consider the prevention or detection of criminal offenses and safeguarding the economic well-being of the state. The rule of law means equality for all. No man is above the law. Not just about judges and lawyers, but it's an intrinsic part of the freedoms and capabilities of us as a people. Whether the legislation is going to be considered virus or ultra-virus, that will be for the courts to consider by looking at the wording of the amendments against the Act as a whole. In my humble opinion, the amendments and the Parent Act recognize the rights of the individual to respect for his private life by establishing measures and procedures for those rights to be judicially considered and dealt with under due process of law, on an equal footing before the law, and with the full protection of the law. That's what this is about. We're not taking away rights. In fact, the accused right to fair trial is being upheld. The special advocate is there for the purpose, is for the benefit of the accused. So on that basis, I don't see the need for a Section 13 requirement. It would be nice to have. I really would have liked for all of us in the Senate to have been unanimous in supporting the legislation because we need it. It is necessary, it is just, and it is proportionate. Nice to have, but not necessary. I thank you.
Senator Haynes.
Thank you, Madam President, for the opportunity to join in this very important debate on the Interception of Communication Amendment Bill. I have noted your rulings before, and I will be very relevant to the amendments. I am also raising my points in context of the removal of the 3/5 majority, Madam President. I just want to start off in my contribution here with a quote from Thomas Jefferson, which is, "He who gives his freedom for safety gets none." And I listened to the contribution by the Honorable Minister of Agriculture, Minister Rambarat, who in his contribution stated that, people are here fighting for the constitutional rights of prisoners, Madam President. And I have a sense of where this debate will go after. I have a sense of what is happening right now. But I just want to, as we all contemplate, and I listened carefully to Senator Vera, who spoke about what privacy means in the 21st century and the concept of data. And in previous debates, I have had cause to discuss what that could mean for us, those of us who are sitting in the legislature now, crafting laws about concepts that we can't even fathom what it may really mean, Madam President. But in this particular piece of legislation, while the focus here is saying to the nation that there are prisoners, persons in prison, communicating with persons on the outside, and we need to put a stop to this, And by intercepting this communication, this is the way we're going to put a stop to it. Are we then because to my understanding, electronic devices in prisons are not allowed. You're not supposed to have them. So are we admitting defeat? Are we saying to the nation that persons who have been convicted and are in jail, who are not allowed to have access to these devices, while they have access now, we are going to bring a whole new piece of legislation and find a way to implement this legislation, even though we can't implement the rules as they are now. That is what we're saying to the population. Madam President, I was discussing with some persons before coming here and talking about why this bill requires a 3/5 majority. I have had cause in this parliament before to say that my fundamental belief in the way governance is supposed to be is that we require smaller, less intrusive government, but more effective governance. That is the way I think about how governance is supposed to work. This administration has been, time and time again, increasing government power via legislation without becoming more effective. So is it by telling the population that you're going to pass this legislation and somehow, by magic, you are going to become more effective, Madam President? And that's where I really find flaws in what the government is telling us here today. You are telling us that after 4 years, with the legislation, with the power that you haven't found a way to be effective. You haven't found a way to effectively protect the people of Trinidad and Tobago from criminals. But with this law, you need this law to be effective. But you're not allowed to have these devices in prison anyway. So I can't see, Madam President, I really cannot see where this idea that we are at war with criminals and we need all the tools in the arsenal to be at war. We can agree with you. But what you have to be is effective, Madam President. And the passage of legislation upon legislation giving more power to an ineffective executive, it just simply will not work. You know, I'm going to ask the Attorney General, I'm going to put a scenario forward, and I just want to know how it plays out once this legislation is passed. My phone number, my personal cell phone number, I have just one, is in fact public information. It goes out on press releases, it goes out on correspondence, it is.
Before you put that question to the Attorney General, let me put a question to you. You have certain amendments. The bill has been debated, went to the other place, debated it comes back here with certain amendments. So you know we're not dealing with the entire bill. Can you therefore, whatever question you're putting, be specific to the amendments that are before us?
Absolutely, Madam President. So it is, like I said, dealing with the removal of the preamble and the 3/5 majority. And the reason I'm asking the question is, this is one of the reasons why I felt as if the bill required that threshold of having a 3/5 majority. So that's the reason I'm posing the question. Given that my number is public information, and also to note that this question of whether or not the conversation is on protecting the rights of prisoners, I want to show how those of us who are citizens, who are law-abiding citizens, are in fact also impacted, and therefore the higher threshold is required. My phone number is public information. Someone within the prison system, due to not being able to manage the system as it ought to be, is in possession of an electronic device and calls my public phone number, engages with me. I don't know who I'm speaking with. Am I in fact caught within this legislation, Madam President? Because it is all well and good for us to say that we pass laws to get bad people, criminals, all the people who did something wrong. But you only have to look around the globe today to understand that by all the good intentions in the justice system and in legislation, sometimes people who did no wrong could get caught on the wrong side. And therefore, legislation is meant to be, the process is meant to be slow, deliberate. You are meant to contemplate all of the eventualities. It's supposed to be a painstaking process because, and it's supposed to be a painstaking process because we're talking about the rights of citizens. Now, Madam President, to be very careful not to re-debate the legislation, but especially when you are talking about that concept of stored data. And I'm not going to go into it in any detail, but if you are talking about being able to access stored data, in my mind, you must need a 3/5 majority, Madam President, simply because I have had a cell phone since I was in secondary school. I have a nephew who is not yet 10 years old, and he has electronic devices. This concept of stored data in just a few years can mean our entire lives. It could be the equivalent of having had somebody follow me around for the entirety of the time that I have existed in the electronic world, Madam President. I don't know what that means for any other citizen, but to me, to people in my generation, that is an increasingly scary concept. That you could, by no fault of your own, get caught in a legislation that allows somebody to go into communication that is the entirety of your electronic life. And if we didn't understand it before, after the COVID-19 situation and pandemic, where most of us, who if you weren't existing in the online electronic community before, you certainly are now, Madam President. If it didn't mean something to you then, it means a lot to people right now. So, Madam President, Senator Hussain did an excellent job in talking about what this means in the context of a democracy. And we are still, as far as I am aware, a democratic state, Madam President. But let us not take this legislation in and of itself, just as an isolated incident. In 2017, that would have been our first year here in the Senate, we debated, 2018, the removal of the SSA from under the Freedom of Information Act, Madam President. And I said in that debate a lot of the things that I had to say here today, which was to caution a government to continue to remove checks and balances, to continue to give unto itself more and more power without showing citizens how it can be effective. And balancing this, balancing our rights and government power in our cities, where we are living in a state where people are afraid for their lives, Madam President, where we are afraid of crime. But to tell us that this legislation is a solution, I think is unfair to the citizenry. As I close, Madam President, I want to point out what we are discussing here today has an impact on us that we may not even be contemplating right now effectively as a parliament, because we don't know what it could mean as far as just 1 year in the future. The constant narrative, Madam President, that as an opposition, we oppose for opposing's sake, I know will find its way into this conversation. And I want to make it very clear to the population of Trinidad and Tobago that where legislation, however crafted, affects the rights of citizens of Trinidad and Tobago, we as an opposition will stand in firm defense of the rights of the people of this country, Madam President. And while we understand that crime is a problem, and a serious problem in this country, I will say it again, There are ways to be effective without eroding the rights of the citizens of this country. And I thank you, Madam President.
Senator Choate.
Thank you, Madam President, for the opportunity to contribute briefly on the proposed amendments to the legislation which is before us. As I understand it, according to Appendix 2 of the attachment to the order paper which we received yesterday, we are looking at subsections 2, 5, 6B5, 7, and the preamble is being deleted. Now, I find myself in a state of some confusion because when the legislation, without the amendments proposed, had been brought before the Senate, it was clear, and the Honorable Attorney General had said it then, that a 3/5 majority was required. I understand that when it went to the other place, a 3/5 majority was not obtained. So this is the first time since I have been sitting as a senator in this honorable House that I have had the opportunity to look at a bill which returns to the chamber for the third reading, and it returns with proposed amendments, apparently not having been contemplated before. Now, I have heard a lot of talk around issues which, with all due respect, I don't think ought to be repeated. So let me put aside for the consideration of those who may be viewing or who may be listening. We already spoke about the level of crime, about prisoners making calls from prison, about Section 13 and proportionality and reasonableness, and all of the things which carry emotional appeals to us. As senators, we are required to look at particular proposed amendments to this legislation. Now, the one thing that is not being said here, but it appears as though this is what is being asked of us, is that when we come to vote on this, that a 3/5 majority be the vote of the House. I would respectfully say that I cannot appreciate or I do not accept the logic behind first coming to us and asking for a 3/5 majority, going down to the House, being defeated, and then returning to us asking for a 3/5 majority. I don't appreciate the explanations, so I don't understand. Perhaps they are beyond me. Perhaps I don't understand the explanations given for this. I call it what it is, a turnaround. And with all due respect, I do not appreciate that sort of practice. But when I look at the proposed amendments, I have to say, and forgive me for speaking with a certain amount of passion, because I had really not intended to, I have never spoken on the third reading of a bill. So this is my first time. So let us look first at the proposed amendments. The Act says in Section 5 that there will be a new word inserted after 4A, that is to say, the word proceedings. But the bite of that comes in section 4, because the act is being amended to apply to criminal proceedings, proceedings under the Proceeds of Crime Act, proceedings under the Extradition, Commonwealth, and Foreign Territories Act, proceedings under the Anti-Terrorism Act, proceedings under the Civil Asset Recovery and Management and Unexplained Wealth Act, unless the trial has commenced and is in progress on the coming into force of this act. For the avoidance of doubt, and this is quite a significant thing, a trial is deemed to have commenced after the evidence has begun to have been led. For the avoidance of doubt, all communications data obtained by a constable prior to the coming into force of this act and lawfully obtained pursuant to sections 32 or 33 of the Proceeds of Crime Act or section 5 of the Indictable Offences Preliminary Inquiry Act shall continue to be admissible into evidence. Let us remember one thing, and perhaps we need to be reminded of this. This act was initially brought to make it easier for evidence to be admitted in the courtroom. We forget, though, that unlawfully obtained evidence was always admissible in our courtrooms, depending on the discretion of the trial judge, taking all things into account. The purpose of this act was sold as saying we are protecting your rights because we are regulating the manner in which such evidence can be used. It can now be used if we can show that the persons collecting the material collected it in accordance with the act. And it is in that context that I respectfully thought that this had been a good idea, because you are making things clearer for the path to admissibility. But with all due respect, this is not the case, because essentially what is now going to be permitted is a level of surveillance and recording for criminal proceedings generally, for proceedings under the Proceeds of Crime Act. And I pause to say I didn't have the time to check the act again, but I do know, for example, that under the Proceeds of Crime Act, even when you go with an order or warrant, legally privileged material doesn't fall within the things that you can take. So you can't take stuff under the act itself, under a warrant or judge's order, but it seems as though you can now record conversations and other data. To me, it doesn't make sense. It doesn't add up. The other thing is, you are talking about a length of time between possible charge and trial, which a citizen, because a prisoner remains a citizen, some of us forget that, charge and trial, which may amount to up to 10 years, during which time that person may be surveilled and recorded. So this piece of legislation has extremely wide, disproportionate, and unreasonable inclusions. If I may move quickly to 6B5, authorized officer. Now, I heard the Honorable Attorney General speak about the DPP and what the DPP wants and this kind of thing. Not only that, what the QC hired to advise the DPP wants. With all due respect, let us not descend to that. That is like when a junior attorney stands up at the bar table and instead of citing a case, says, my senior says this is what the law is. This is the highest court of the land. Let us maintain our standards. 6B5. Authorized officer now, I was hoping to see after all this importance being placed on the DPP that he may have been included, but he is not included, even though his name is called as being the justification for some of these amendments. In the interest of national security. Now, we know that there are people who will need to have that information in the interest of national security. Let us not pretend that we don't know that terrorism is a live issue for any minister of national security, for example. So I don't necessarily have a problem with that. But look at subsection 2, for the prevention or detection of an offense under this act, or for which the penalty on conviction is imprisonment for 10 years or more, and includes an offense where death, imprisonment, or the remainder of a person's natural life is a penalty fixed by law. Now, perhaps we ought to have been given a list of all of the criminal offenses for which the penalty on conviction by imprisonment for 10 years or more is contained. Such a list would have assisted us, and I think it would have demonstrated that there are many offenses, perhaps from assault right back, which would fall under the breadth of this subsection. It is way too wide, it is disproportionate, and without proper justification at the third reading of this bill, of this act, it is unreasonable. Now, for the purpose of safeguarding the economic well-being of the state, well, that could mean anything and nothing. And if you want to request a 3/5 majority for the passage of a piece of legislation, then at the very least, the senators could have the respect of having language which is precise and clear. And for the purpose of safeguarding the economic well-being of the state, I don't know that there is a crime which says that you are jeopardizing the economic well-being of the state. So I have no touchstone for interpreting this phrase. So it means that this phrase may be interpreted in any way by anyone, and that is dangerous. Now, Section 7. To make it worse, Section 6B1, after authorized officer, following words are included. Prevention or detection of an offense under this act, or for which the penalty on conviction is imprisonment for 5 years or more, etc. Well, the point I made in relation to the 10 years would certainly have helped us and would shown us how unreasonable this section is, because just off the top of my head, I can tell you that a simple assault attracts a penalty of 5 years. So it means that somebody charged with simple assault is now liable to lose his privilege against self-incrimination taken away, his right to silence taken away, evidence collected in his absence, without his knowledge, and capable of being used against him in a court of law until he finds out 10 years down the line when he comes to trial. And I think when we look at the legislation, we have to consider practically how it's going to work out. And there has been data given and lofty comments about rule of law and how it works and that kind of thing. But you know what? The average citizen wants to know the nitty-gritty. How is this going to impact the system which we use? And that is one thing that has not been discussed thus far in this debate. Again, we find a phrase, for the purpose of safeguarding the economic well-being of the state. And quite frankly, I must confess, and perhaps it is because, it is beyond me, but I have no idea what that is supposed to mean or what it is capable of being interpreted as meaning. So the long and short of it is that, in my respectful view...
Senator Choate, you have 5 more minutes.
Thank you. In my respectful view, what is proposed here makes it even more clear that we need a 3/5 majority for the reasons that I have advanced. I'm not saying that everybody has to agree with me, and most of you may not. But quite frankly, that is the way I see it. Madam President, thank you for allowing me to make my contribution.
Attorney General, honorable senators, at this juncture, the sitting will be suspended. We will return at 2 p.m. And I will remind members that on the return, 10 senators are required to be in this chamber. So we are suspended until 2 p.m.